On the record in the matter of the people of the state of Michigan versus John Adam Belton, 24-02579. Mr. Belton, can you hear me?
Yes.
Okay, Mr. Belton, today was the date that was scheduled for an arraignment for a probation violation. I do have here a request and summons for probation violation. The allegations are that you failed to report to probation back in January 2025, that you failed to make payments, the balance being $125, and that you failed to perform 40 hours of community service within 60 days, and says no hours were reported completed. I also have an additional violation stating that you failed to follow the circuit court probation orders, and that on January 23rd, 2025, you pled guilty to a probation violation, and a violation on January 13th, 2025, you tested positive for methamphetamine, amphetamine, and fentanyl, and that you were sentenced to TRICAP. So you have the right to a contested hearing for these violations. You have the right to be represented by an attorney at that contested hearing. If found to be in violation of your probation can be revoked and you can be sentenced to a term of jail. Do you understand that?
Yes.
Did you want to request an attorney to represent you for the violation?
Yes.
I'm gonna enter a plea of not guilty on your behalf. We'll set this for a hearing.
April 7th at 1:30.
April 7th at 1:30, and then we'll get a public defender online right now to meet with you to get some information from you.
Okay.
What I show you there. Do you have any questions for the court?
No.
You'll be back.
Hang tight, we'll get you in a private meeting room in just a moment.
Thank you.
Okay, are we having a hearing on Blundell?
No, Your Honor.
On the record in the matter of the people of the state of Michigan versus Cadence Blundell, 24-02054. Appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Warren Sutter on behalf of Ms. Blundell, who is approaching counsel for the now.
Okay, Blundell was scheduled for a hearing for a probation violation that she was previously arraigned on. The violations allege that she failed to refrain from alcohol, that she had not provided any proof of 12-step attendance and probation, which was supposed to be one time per week, and that she had not provided any proof that she's completed a victim impact panel within 90 days. And then it looks like there's another violation that she was arraigned on as well. It's for failure to demonstrate 10 hours of community service that was supposed to be completed by January 9th. And no proof of enrollment in a GED high school diploma program as ordered by the court. So she wants to plead guilty to those violations.
So, Your Honor, I believe Ms. Bayless emailed the court earlier today asking for dismissal of violation number 19, I believe, and no proof of BIP, as a certificate of completion has been submitted for that.
Well, let me, well, just a moment. When time did
She didn't
Oh,
send it to
8.
you. I just forwarded it to you though.
Oh, she didn't say that to me.
And then there's one additional, I'm going to ask the court to consider holding an abeyance with a plea on the remaining. And I can tell the court why.
Okay, so Lucian, when did she complete this? I can't, I can't do it with. To March 2nd or 22nd? She was supposed to have it completed when? the victim impact panel was supposed to be completed by February 3rd, correct?
I believe that is correct, Your Honor.
What else do you have?
Your Honor, I'm gonna ask the court to consider holding violation number 12 in abeyance. She has completed the hours. She has submitted the documents for the overseer to sign off on, and that person hasn't sent them back to her yet to provide to Jody. She has completed the hours. She's just waiting on signature. She provided to me today the contact information for that person, that they just haven't gotten back to her yet.
Where do you complete your hours?
Housing Services of Mid-Michigan.
Okay. And person that was supposed to sign off on it.
Dennis Mast signed off on the majority of them. I believe it is Kylie McKay who was gonna sign off on the remaining hours. She just hasn't sent them back yet with her signature.
Okay, so let's see. She was supposed to complete her service hours by January 9th. When did she complete them?
She doesn't remember the exact date of the last one. She believed it was the week around St. Patrick's Day.
Okay, so in March, or around 17th, her hours were completed. Okay, and then it looks like that same week, she did do her victim impact panel. What about high school enrollment?
That is something she's still working on, Your Honor. We talked about that earlier today. I think she's hoping on going this weekend one because it's just walking in to sign up, correct? Yes.
And what about the 12-step attendance?
She has been doing attendance there. She does admit it is not quite at the frequency the court has ordered. I reminded her today that Zoom AA attendance can be an option. She was unaware of that. She's going to we talked to Ms. Bayless about whether she will be permitted to do AA attendance. She's struggling right now. She knows it's free. She's struggling with the work scheduling and doing it and going in person. And I do think her doing attendance with AA on Zoom would allow her to do during lunch breaks, after hours, at night, something that she didn't appear to be aware of before.
Just to be clear, you are waiving your hearing, correct? You don't want a hearing today on your violations. You understand that you had the right to have that hearing today to have the prosecutor prove or establish that you made these violations of your probation?
Yes.
And no one's threatening you to waive your hearing or giving
No.
no promises being extended to you if you waive the hearing? Is anybody promising you anything to
No.
plead guilty to these
No.
violations?
No, Your Honor.
Okay, and so you want to plead guilty freely and voluntarily?
Yes.
Okay, and there's a request for me to essentially hold in advance what about the community service, and then Ms. Bayless is requesting a dismissal for one because it was completed. However, my concern is none of these things have been done on the date that she was ordered to do them. And so that is what my bigger issue is here. What are you doing for work?
For work, I work at Crumble Cookie.
And so working at Crumble Cookie is prohibiting you from doing your treatment and following the order of the court? Or what is it that's causing you not to get it done?
No, I could cut back my hours to do that, and that is on me for not doing that. I have just been working a lot, but I can.
What hours do you work at Crumble Cookie?
It varies between 25 to up to 30.
Per week?
Yes.
It sounds like you have plenty of time to do what you need to do. It doesn't sound like you need to cut back on your hours. It sounds like when you have your free time, you need to do it. What else are you doing when you get off Crumble Cookie? What are you doing after work?
I guess, yeah.
Hanging out?
Yeah, yes, yeah.
How old are you?
19.
You look much younger than that. Just want to put that out there. But do you want to work at Crumble Cookie for the rest of your life? Or do you have plans to do something else?
Right now I see myself going higher up with Crumble because I love what I'm doing and I love the people that I work with there. So
Maybe
I would-
management at Crumble
yeah,
Cookie?
yeah.
You think a high school diploma would help you do that?
Yeah.
So
Yes,
what's holding you up from going down there and signing up for your classes?
I just need to do it and I understand that now.
I don't know why you didn't understand it when we first put you on probation.
If I'm.
Yeah.
So some of what some of what we've talked about is she has admitted to me, she has been diagnosed with OCD. She struggles with doing many things at once. She is a person who struggles to do anything other than completely doing one thing and then completely doing the next thing. So she is struggling to do all these orders of the court. We've talked about it before. I do think she's trying, and she acknowledges that she is struggling. She knows the court is telling her she needs to juggle things. She needs to do multiple things at once, and she's struggling there. So I think she's working on, as she's getting older and going through this process, learning how to do more than one thing at a time, because adult life requires you to do more than one thing at a time. I think I am seeing some growth in her in doing that, particularly with she has been in these community service hours, is something she's talking about for the last several months is getting these hours done. I've dealt with Mr. Mass before. I've talked to him about this, and she acknowledges she's struggling. She's acknowledging that she's not doing this in the timeline the court ordered. She knows that she is struggling with more than just work right now. It is a kind of mental barrier that she's trying to get over, and I do believe she is trying her best to get over it. She knows she needs to do it.
She works at Crumble Cookie. She's got to do more than one thing at one time at work. And she wants to move higher up. You're going to have to multitask. All of us have to do more than one thing at one time from time to time. No one said that you needed to do the 12-step and the VIP at the same time. That's not what we said. We gave you plenty of time. None of these things are requiring you to do them all at the same time. Keeping up with deadlines and dates. What kind of phone do you have? iPhones come with calendars, and they can send all kinds of fancy reminders. You don't even have to remember it yourself. When you get this level of complexity to your life where you got to be pulled in different areas at the same time, you start relying on your calendar more to remember. You know, I got a deadline, I got to do what I got to do. It can't be I go to Crumble Cookie and then I spend the rest of my time doing what I want to do, and then I come into court and cry because I didn't do what I was supposed to do. You've got to take responsibility for your actions, not just during the 30 hours a week that you're working. At all times. You have entered into adulthood. You've also entered into adult criminal actions. And so now you got to take responsibility and get on track. And so I'm not just going to dismiss a violation because you took care of it after I told you to take care of it. The best I'm going to do is I'm going to hold this entire ordeal in abeyance so that you can go and bring proof that you've done everything you were supposed to do. I want you enrolled in a GED program immediately. I want you attending your 12-step program meetings. You can call your probation officer, text your probation officer, email, go down one form, you leave here, whatever you need to do to make sure you get clarity as to what your options are so that you can make sure that your treatment fits into your life the way it needs to, because it needs to fit into your life. Otherwise, you won't be working at Crumble Cookie. You will be at jail. Do you understand that?
I do.
Okay. As to the alcohol, there's nothing you can bring me unless you're bringing me some proof that you didn't drink, and you have no business drinking because you're under order not to be drinking. And so I better not get another violation between now and this next court date. The only thing I better get is documentation that you have brought everything into compliance. Do you understand that?
Yes.
Let me get it. What's our next available date? So 2 weeks from now?
Yeah,
That's not done.
April 7th.
April 7th at 1:30.
And just to be clear, you're holding all of the violations in abeyance for that?
That's correct.
Thank you.
Get your notice to appear. Do you have any questions for the court at this time?
No, ma'am.
Any additional matters for the record?
Nothing further.
We're all set for now. I thought that maybe James was going to meet with
Yeah, we're looking for him.
Mr. Belton. No, I thought James was going to log in and meet with Mr. Belton.
Right, we just.
Oh, okay. Okay, have we seen Luis de Juarez? No? Have we seen Joseph Gordon?
Yes.
Okay, State of Michigan versus Joseph Gordon, 24-02115. And Mr. Gordon, I have a request and summons for probation violation. The allegations are that you committed a technical violation per incident report number 2025-899. Defendant was arrested for a felon in possession of a firearm on February 21st, 2025 in Eaton County. So you have the right to be represented by an attorney. You have the right to have a contested hearing. And if you're, and you have the right to have a hearing and have the prosecution establish if you were guilty of the alleged violation. If you're found to be, I'm sorry, James, are you supposed to be meeting with Mr. Belton?
I also was gonna be handling his arraignment since he has applied and was gonna get the,
Okay, well, Mr. Belton's been waiting. I handle all the arraignments. No, you stand there, sir. I handle all the arraignments to stay. He's gonna, if he's requesting public defender, he's getting a not guilty plea. That's all we needed to know. But Mr. Belton's gotta get someone to meet with him. Okay, so again, you have the right to have the prosecution. Sir, I'm still talking to you. The prosecution proved the violation. Do you understand that?
Yes,
Okay, and so you've requested a public defender to represent you from this violation, correct?
yes,
To enter a plea of not guilty on your behalf. This will be set for a probation violation hearing. I'm imagining that you have a preliminary examination or you've already had one in the other matter. Did you have one already?
yeah.
Is it bound over?
They offered me a deal. and
You waived the exam. Okay, you waived it.
Probable cause I went to.
Okay, give me a hearing. April 7th. Hearing is gonna be April 7th at 1:30.
I got one question.
Yes. What's your question?
Will I, be able to have like my witnesses that day?
Yes, yep, you can have all your witnesses at the date set for the hearing.
Okay, thank you.
Okay, and you talk to your attorney about that. We'll get you a notice for the hearing, okay?
Yep.
Okay, hang tight for the notice and then you'll be all set. You can have a seat back there though. Jacqueline Montalvo is present.
yes,
Okay, are we having a hearing on that?
will be a plea, Your Honor.
Matter of the state of Michigan versus Jacqueline Montalvo, 20-03011, appearance, please.
George, and on behalf of the people, Jacob Riley on behalf of Ms. Montalvo.
Okay, Ms. Montalvo was scheduled to have a hearing on the violation alleging that she tested positive for alcohol on February 3rd, 2025. That's all I have. And that's what she's pleading guilty to.
Yes, Your Honor.
That's correct, ma'am? Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Okay, you can put your hand down. You understand the purpose of a contested hearing? Okay, Okay, so you have the right to require the prosecutor prove the violation and you don't have to plead guilty to that. Do you understand that?
Yes.
Do you want the prosecutor to prove it, or did you want to waive your hearing and plead guilty?
I'll leave that.
Is anyone promising you anything to get you to plead guilty?
No.
Has there been any threats to make you plead guilty?
No.
As to the violation that you tested positive for alcohol on February 3rd, 2025, ETG 2,530.983 nanogram per milliliter and an ETS of 1613.386 nanogram per milliliter. How do you feel? Absolutely.
Ms. Montalvo, is it true that you were sentenced to a term of probation by this court in December of 2023?
Yes.
Is it true that one of the terms of that probation was that you were to abstain from any alcohol use?
Yes.
Is it true that you violated that probation by testing positive for alcohol on February 3rd of this year?
Yes.
Thank you.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to make freely, voluntarily, and intelligently. I'm not 100% sure I understand the recommendation. She's supposed to be on probation until July of this year. The recommendation is to terminate probation and refer the balance to collections.
I was also confused with that, Your Honor, and I was gonna allocate for an extension of probation, put her back on a scram tether, and hold any jail punishment. My recommendation would be 10, 15, 20 days in abeyance of any further violations. I believe, from what I see, this is a person with a problem that needs some help. And I believe one way to control monitor that would be a GPS tether. I think that's probably the best bet in this situation.
Mr. Allen.
My request would also be to keep Ms. Montalvo on probation through her expected end date in July. I think she certainly has benefited from probation. She unfortunately had this lapse in February, and she has been working very hard to maintain sobriety. It was really an unfortunate incident, but she's not. She hasn't fully fallen off the wagon, so to speak. I think she's committed to continuing her probation, seeing it through. She knows how important it is that she maintains sobriety at this point in her life.
Does your client wish to make a statement?
Yes, Your Honor. You know, when I started the probation, it was a really rocky start. And for the last 36 weeks, aside from this incident, I've been sober and I've been working on my health, mentally, physically. And I want to stay sober. That's my main goal right now.
I don't know what it's gonna take for you to remain consistent. I mean, I had to put you on scram tether previously because the amount of violations that we had, and I wanted an opportunity to test you more frequently, and you did well. And then once that measure was no longer in place, I now met with this violation. And so I think the court has to go in a different direction, because if you've done all of the intensive outpatient and the outpatient and it's still not working, that's largely due to your desire to want to make it work. You have to can be given all the tools that you possibly need, but until you make a decision to be intentional about your actions, it's not going to be a role that's successful for you. The recommendation to me, I don't know if it was made in error. It caused me a bit of confusion because you still have a considerable amount of time, a few months on probation. You're supposed to be on probation until July 18th. And so at no time would I give you a reward of terminating you from probation and no longer any oversight unless I was sentencing you to jail for the remaining time period or for a term. What I will do, however, is I am going to sentence you to 30 days Ingham County Jail. However, I'm going to hold that in advance. You're gonna get a scram tether. For the next 90 days. And you're going to continue your probation with scram tether, any violation of the scram tether, and that will include confirmed tampers of the tether. If I get any of that, then you'll just do the 30 days. And then we all can go our separate ways, okay, ma'am?
Yes.
Do you have any questions at this time? You need to report to Ingham County to get your tether today, okay? Why is that?
Because my ride has to go somewhere after this.
I got a couple options for you. I can remand you and then we can get you there.
I can get there for sure first thing in the morning.
Okay, we'll take that.
Thank you.
All right. First thing by tomorrow, you need to have this tether on, okay?
Yes.
Any additional matters for the record?
No, Your Honor.
Oh, Your Honor.
Thank you. You're all set. Jacob Mullins here. Yeah, or you get. Where is he? In custody? He's on Polycom, where? Oh, they put up, where's his attorney?
I'm the attorney to the judge.
Okay, you can bring Mr. Mullins back out of the Polycom or out of the breakout room. I suppose. On the record in the matter of the people of the state of Michigan versus Jacob Edwin Mullins, 24-03520 and 25-00212, council appearance.
George, in behalf of the people.
Jacob Raleigh on behalf of Mr. Mullins.
Mr. Mullins is present via Zoom, via Polygon from the Ingham County Jail. I do have a report from the Department of Health and Human Services Center for Forensic Psychiatry. It was dated prepared March 12th. Council, did you get a copy?
Yes.
Yes, we do.
Okay, the report opines that Mr. Mullins was evaluated on March 7th, and the opinion is that he is not competent to stand trial. Any reason to make objections to the report?
Yeah, for sure.
He's deemed restorable, but not at this time. Well, they believe he could be restored.
I'm submitting for that report. I believe defenses as well, Your Honor, and I believe we're gonna be requesting the AD upon his fingers up.
If I may speak, Your Honor,
Yes.
I would like to make a formal objection to the competency hearing. I'd like to challenge the jurisdiction that they ever had the right to enact it in the first place. I'd also like to appoint you as trustee for the case.
I'm sorry.
The Honorable Judge. I'd like to appoint the Honorable
Thank you.
Judge Simmons as trustee for this case, and I'd like to
Thank you.
challenge jurisdiction.
Thank you. That's been noted on the record. Mr.
I would just put a hold on this case pending him receiving the psychological treatment to see if he's competent to stand trial.
Thank you, Mr.
Objection.
Riley. But Mr. Riley, I'm gonna mute your client so that we don't have any further outbursts. Did you want to make any other statement? His objection's been noted on the record. It's not meaningful. It's overruled. There's no reason to object. You're not given any reasonable basis, and the court will not act as a trustee to your case. Nonetheless,
Your Honor, I would stipulate to the findings and recommendations of the competency evaluation report.
oh, okay, the court will adopt the findings of the report. It will be incorporated into the court record, and he will be ordered to undergo treatment at the Department of Health and Human Services Center for Forensic Psychiatry, with the hopes that he can be restored to competency. And we'll put the review date out and hold any next action dates until that time. I think I have an order here. Any additional matters for the record?
No, Your Honor. No, Your Honor.
Thank you. You're all set. I have two orders. Mr. Mullins, you're all set. They can, someone notify the jail that he's all set. Okay, let's see.